There's no denying that any divorce can be a difficult and painful time for most families. However, from a legal standpoint, there's an easy way and a hard way when it comes to divorce. Uncontested divorces tend to be a much more straightforward and affordable option than contested divorces. But remember, divorce laws vary from state to state. So let's take a look at the contested and uncontested divorce processes in the state of Maryland to make sure you're ready to protect yourself and your family if the time comes. A contested divorce occurs when one or both spouses disagree on various issues related to their divorce. These tend to revolve around child custody, property assets, alimony, and child support. Just because a divorce is contested doesn't mean it will go to trial. However, if agreements can't be reached, a judge will need to determine who gets what. Here's how the typical contested divorce process works in Maryland. The first thing you will need to do is file a divorce petition against your spouse with the courts. This petition will include a variety of information, including contact details, marriage specifics, the reason you're seeking a divorce, your custody wishes, and more. It's important to note that Maryland's divorce law changed recently. In the past, you were able to seek a limited divorce. Now, the only option is an absolute divorce, and the grounds available for it have changed. There are now 3 grounds for divorce. They include a 6-month separation before filing for divorce, irreconcilable differences you both can't resolve, and mutual consent between both parties. If one of these legal grounds doesn't apply to you, you can't get a divorce. Once you've filed the petition, you'll need to make copies. Then you'll bring the document to your local courthouse. You'll pay a filing fee and give them the original document. However, you should keep at least 2 copies, one for yourself and another one to serve to your spouse. Once you serve your spouse with the divorce papers, they'll have a period to respond. If they're in Maryland, they have 30 days. If they're in another state, they have 60 days. And if they're out of the country, they have 90 days. If they don't respond, you can begin a default divorce. If your spouse has allegations they want to file against you, they can fill out a counter complaint, which they'll deliver to the court. This will then need to be served to you. Now, if your contested divorce is proceeding to court, you will likely enter a discovery phase. During this time, the court will provide both spouses with a deadline. Before the deadline, lawyers on both sides can request a variety of information. This might include things like depositions, where your lawyer interviews your spouse. Interrogatories, which are lists of questions your spouse must answer, are also common. You're also entitled to ask for specific documents. Things like credit card statements can help your lawyer establish spending habits. If your partner refuses to provide a certain document, you can issue a subpoena to obtain it. It's important to note that not all contested divorces will require discovery. However, all courts in Maryland do allow it. This phase is why it's really important to pick the right contested divorce attorney. The evidence you get during the discovery phase will often determine the strength of your trial case. It can also be used to negotiate a more advantageous settlement. Divorce mediation is the process of hiring a mediator who works with both sides and their lawyers to reach an understanding of contested matters. A divorce mediator is not the same as a lawyer. They're an objective party that works to resolve disputes. Typically, the court will be encouraged to seek mediation voluntarily. However, in Maryland, the judge may force you to go through court-mandated mediation. Just keep in mind that even if you need to go through mediation, you're not required to come to a resolution regarding your contested divorce. Mediation is private, so you don't need to worry about things you say being used against you in a trial. If you can reach an agreement, the mediator will draft together a marital settlement agreement. Keep in mind that this settlement can be reached at any time during the divorce process. However, you will need to meet with the judge to confirm that no one forced the other party into the agreement. If you can't resolve your differences, your contested divorce will go to trial. During this trial, both sides' lawyers will make arguments, interview witnesses, and present evidence to the judge. In some cases, experts may be called to the stand to make the argument that one partner is more fit for custody than the other. Once the trial is over, the judge will provide you with a divorce decree. This will contain all the information related to the verdict. If you ever want to modify this document in the future, you will need a Maryland court order to do so. Uncontested divorce proceedings occur when both parties agree on all of the issues and reasons related to the divorce. It requires the couple to draft and sign a settlement agreement, which they must provide in person to a judge. As you can guess, a no-fault divorce is quick, simple, and far less expensive than a contested divorce. Here's how they typically work in Maryland. When you file your divorce forms, you'll need a completed and signed settlement agreement as well. As such, it makes sense to get it over with before the proceedings. We recommend sitting down with your spouse to negotiate the specific terms of this agreement. In some cases, you may want to have a mediator or lawyer present. That's because big things are at stake in the document, including how you will divide assets, child custody arrangements, and alimony and child support payments. We always recommend having your lawyer review the contract before you sign it. That way, you're sure that you know all the terms surrounding your divorce. Once you finish your settlement agreement, you'll file for a divorce with the courts just like you would in a contested divorce, making sure to mark mutual consent as your grounds for getting the divorce. In addition to the settlement agreement, you'll also need to include financial statements and a civil domestic information report. If you both have children, you'll also need a child support worksheet and parenting plan. If you can't afford the filing fees, you can include a filing fee waiver. Once the courts have reviewed all your paperwork, they'll ask for a mutual consent divorce hearing. Typically, only one spouse needs to be present at this hearing. During this hearing, the judge will review your settlement. If there are no problems, the judge will approve your agreement and the divorce will be final. There's no denying that an uncontested divorce is a more attractive option for most families. It's going to save you a lot of money and time, and that's not to mention the peace of mind that comes with ending a painful marriage as soon as possible. In a perfect situation, spouses should always try to reach agreements through mediation first. However, sometimes divorces aren't so simple. Here at Blattner Family Law Group, we know that different individuals have different needs when it comes to divorce. So, schedule your consultation with us today to sort out what path is best for you and for your situation, and to start getting the help you need.